Buti pre dumating ka, may tatanong sana ako sa'yo eh.
Ano yun?
Nagbayad kasi ako ng utang via GCash. Na-receive ko naman yung confirmation. Kaya lang, hindi daw natanggap ng sinendan ko. Baka ireklamo ako nun. Paano kaya yun?
Meron ka namang na-receive na resibo galing sa GCash.
Meron naman.
Oh, may ebidensya ka naman na nakabayad ka na.
Oo, kaso nasa cellphone yung resibo. Paano kaya yun?
Okay lang yan. Meron naman tayong tinatawag na Rules on Electronic Evidence.
Ha? Ano yun?
Kailan yung nagsimula?
In 2000, the Philippine Congress passed Republic Act 8792, also known as the Electronic Commerce Act. The authentication procedures outlined in RA 8792 will have to be followed until such time when the Supreme Court will have provided the appropriate rules for authenticating and validating electronic documents, data messages, and signatures. On July 17, 2001, the Philippine Supreme Court approved the Rules on Electronic Evidence, which took effect on August 1, 2001. The rules stated that it shall apply in all civil actions and proceedings as well as quasi-judicial and administrative cases. The succeeding year, the coverage of the Rules on Electronic Evidence was expanded to include criminal cases through AM 01-7-01 dated September 24, 2002.
Yeah, boy.
Saan at kailan naman yan dapat gamitin?
This rule applies whenever an electronic document or electronic data message is offered or used as evidence. It shall also apply to all civil actions and proceedings as well as quasi-judicial and administrative cases. In all matters not specifically covered by these rules, the rules of court and pertinent provisions of statutes containing rules on evidence shall apply.
Nice.
Ano-ano ba itong mga electronic evidence? Pwede ba itong gamitin sa korte?
Whenever a rule of evidence refers to the term in writing, document, record, instrument, memorandum, or any other form of writing, such term shall be deemed to include on electronic document. Electronic evidence is admissible evidence if it complies with the rules on admissibility prescribed by the rules of court and related laws, and it's authenticated in the manner prescribed by these rules.
Kaya lang, paano malalaman na original or authenticated yung electronic evidence?
Sabi dito, an electronic document shall be regarded as the equivalent of an original document under the best evidence rule if it is a printout or output, readable by sight or other means, shown to reflect the data accurately.
Defeat!
Paano naman yung mga xerox at duplicate?
Damn! Interesado na siya forget defeat.
When a document is in 2 or more copies, executed at or about the same time, with identical contents, or is a counterpart produced by the same impression as the original, or from the same matrix, or by mechanical or electronic re-recording, or by chemical reproduction, or by other equivalent techniques, which accurately reproduces the original, such copies or duplicates shall be regarded as the equivalent of the original. Notwithstanding the foregoing, copies or duplicates shall not be admissible to the same extent as the original if, first, a genuine question is raised as to the authenticity of the original, or second, in the circumstances, it would be unjust or inequitable to admit the copy in lieu of the original.
Oh my God! Wow!
Sino ba magpapatunay ng authenticity ng isang electronic evidence?
At paano ito yung mapapatunayan?
The person seeking to introduce an electronic document in any legal proceeding has the burden of proving its authenticity in the manner provided in this rule. Before any private electronic document offered as authentic is received in evidence, its authenticity must be proved by any of the following means. First, by evidence that it had been digitally signed by the person purported to have signed the same. Second, by evidence that other appropriate security procedures or devices as may be authorized by the Supreme Court or by law for authentication of electronic documents were applied to the document. Or lastly, by other evidence showing its integrity and reliability to the satisfaction of the judge. Also, A document electronically notarized in accordance with the rules promulgated by the Supreme Court shall be considered as a public document and proved as a notarial document under the rules of court.
Wow naman! Wow! Wow!
E paano naman yung digital design? Papasok ka sa computer sa kakapipirma?
Bobo alam bang hindi?
Kaka-ML mo yan, boy!
Electronic signature is any distinctive mark, characteristics, and or sound in electronic form representing the identity of a person and attached to or logically associated with the electronic message or electronic document or any methodology or procedure employed or adopted by a person and executed or adopted by such person with the intention of authenticating, signing, or approving an electronic data message or electronic document. An electronic signature or a digital signature authenticated in the manner prescribed in this rule is admissible in evidence as the functional equivalent of the signature of a person on a written document. An electronic signature may be authenticated in any of the following manner. First, by evidence that a method of or process was utilized to establish a digital signature and verify the same. Second, by any other means provided by law. Or third, by any other means satisfactory to the judge as establishing the genuineness of the electronic signature.
So once an electronic document is signed, is it 100% authentic?
Stop it. Get some help.
Damn! Spinning dollar!
Sabi sa batas, upon the authentication of an electronic signature, it shall be presumed that, first, the electronic signature is that of the person to whom it correlates. Second, the electronic signature was affixed by that person with the intention of authenticating or approving the electronic document to which it is related or to indicate such person's consent to the transaction embodied therein. And lastly, the method or processes utilized to affix or verify the electronic signature operated without error or fault.
Ayaw mo kaulaw nga ikaw nga nagsayaw sasayaw sa manubo.
Teka. Katatapos ko lang isulat ang mga letra.
Eh, paano naman pala yung mga audio tas pictures at video na hindi naman napipirmahan?
Well, audio, photographic, and video evidence of events, acts, or transactions shall be admissible provided it shall be shown, presented, or displayed to the court and shall be identified, explained, or authenticated by the person who made the recording or by some other person competent to testify on the accuracy thereof.
Okay. Yung text messages tapos chat sa messenger.
Well, ephemeral electronic communication refers to telephone conversations, text messages, chat room sessions, streaming audio, streaming video, and other electronic forms of communication which the evidence is not recorded or retained, but it shall be proven by the testimony of a person who was a party to the same or has personal knowledge thereof, and in the absence or unavailability of such witnesses, other competent evidence may be admitted.
Nice.
Wag ka na mawala, wag ka na mawala. Ngayon, dadaling kita sa bahay.